a battery, domestic violence here in Central Florida, that charge can actually come in two different forms. And we defense attorneys, we have to watch what is actually being charged in a case like this, because the prosecutor has two options. Number one, you can charge battery, domestic violence where your client caused harm to another individual, right? That is battery. You caused harm to another individual. That's battery, domestic violence. It's a first-degree misdemeanor here in Florida. You actually get a little mandatory jail on it, a couple weeks. You can get up to a year in jail, and it comes with mandatory counseling and a lot of baggage. Or, rather than battery, domestic violence causing harm, you can also get an intentional touch against the will of another person. So it's not that you caused any harm, but you intentionally touched. You didn't accidentally bump them, and that touch was against their will. That is the same crime as causing harm. Both are battery, domestic violence. Now, we're going to talk about the case of Hollis v. State. And in Hollis, he was charged with battery, domestic violence causing harm to another person. The state realized right before trial that I don't know if we can prove that any harm was caused. So let's add a phrase to the charging document that we call an information. Let's add, you know what? Hollis caused harm and or intentionally touched this person against their will. And Hollis was found guilty of battery, domestic violence. But on appeal, Hollis's conviction was thrown out because the court said, you got to pick a lane and you got to drive in it. How do we know what crime Hollis actually committed? The way this thing is charged, did Hollis commit battery by causing harm, or did Hollis commit battery by intentionally touching somebody against their will? They're both the same crime, but you gotta tell Hollis what he did wrong so that he can defend it. And they didn't do that. They charged him with both, and the court said that was improper, and they threw out the conviction. So we defense attorneys, we have to look very closely at what the prosecutor's actually charging you with. I think the smart move for most prosecutors, but they don't all do this, the smart move is to always charge it as an intentional touch against the will of the person, because that way you don't have to prove harm. But I'm not a prosecutor, never have been, never will be. I've been defending cases here in Central Florida for over 31 years. So I hope you don't have one of these battery domestic violence charges here in Central Florida. But if you do, I hope you will call me and let's see if we can help you out. I think we can. And thanks for watching, by the way.